Given to him by the builder or the seller. So we consider that as an admission on the part of the condominium builder or seller that the transfer, the complete transfer of ownership and the free, intelligent, and voluntary acceptance of possession occurred on August 12, 2009, regardless of the provisions on deemed acceptance and the issuance of title in 2004.
Your Honor, for the part of the prosecution, our inquiry with the Civil Service Commission, they informed us, Your Honor, that the SALN form itself, as well as the provision of the Constitution, the Anti-Graft and Corrupt Practices Act, as well as Republic Act 6713, clearly states that whenever an asset, Your Honor, is acquired, it must be stated. And as duly noted by the presiding officer yesterday, Your Honor, when payments were made in 2003 and in 2004 for this particular unit, an asset should have been declared by the respondent, Your Honor, because asset it has an accepted meaning, Your Honor, and no quibbling on the meaning of asset should be debated upon, Your Honor. An asset, when you take out the cash from your pocket, then you get an asset. And this is what we are trying to point out. Acceptance of the unit, Your Honor, is of no moment because in 2003 as well as in 2004, an asset was acquired by the respondent already.
Your Honor, just very briefly, supposing the condominium had never come to be, would that 3-point-something million still be an asset? It would have become a liability.
It is, Your Honor.
If that condominium unit never came to existence and no delivery was had, it could not possibly have become an asset.
Not a liability, it would be a receivable.
Receivable.
Mr. President.
Well,
Mr. President.
Yes.
Gentlemen, may I still...
The gentleman from Cebu.
May I
the
have...
floor.
no, I was just going to ask the
I thought
permission.
it was the
With
lawyer's
the
stuff.
permission of the gentle lady from Iloilo.
Thank you, Madam Senator. I think the Senate President has a better understanding than most of us do of the concept of assets and liability. An asset can be cash, it can be a receivable, it can be a property, and it should have been booked maybe as a accounts receivable from Ayala Land. If the unit was never delivered, even in 2010, that 3.5 million should still have appeared in his asset side. Otherwise, we have a David Copperfield thing. Now you see it, now you don't. Obviously, there was 3.5 million taken out of the asset side of the SALN of Justice Corona and given and paid to Ayala Land. So ano po nangyari doon? Hindi naman nag-appear in 2003, 2004, 2005, 2006. Then all of a sudden, it appears as a condominium in 2010. The condominium is irrelevant. The value must appear. That's what we're saying. Thank you, Mr. President.
Mr. President, I stand corrected. If the condominium had not appeared, that is right. It would still be a receivable. That is right.
One more question for the prosecutor and then I am done. Mr. Prosecutor, are you familiar with the word tradition in the law of sales?
Yes, Your Honor.
What does it mean?
Your Honor, tradition means that there are other forms of delivery rather than other than actual delivery of the property, Your Honor.
Are you sure that is the meaning of tradition?
That is as my recollection would serve me, Your Honor.
Maybe you need some multivitamins for neurons in your brain, because that is not the meaning of tradition. Tradition comes from the Latin word, which means to, like for example, to translate. That is a relative of the word tradition, meaning to say, to convey, to give manually. That is quoted by Manresa, who is the favorite basis of all our civil code writers. And Manresa insists that tradition is part of the transfer of ownership. That is what he says. He is, of course, the father of the civil code, at least as known in our country. And according to him, ownership does not pass by mere stipulation, but only by tradition.
Tradition.
He says, The delivery of the thing signifies that title has been passed from the seller to the buyer. So my question to you is, has there been tradition in the sense used by Madrasa and our other civil code authors like Tolentino, etc.?
Yes, Your Honor. We believe so, Your Honor. By execution of the deed of absolute sale, Your Honor.
All right. I'm very satisfied with the answers of both counsel. Thank you, Mr. President.
Thank you, Your Honor.
Counsel,
Senator Drilon, Mr. President.
gentleman from Iloilo.
Yeah, just a few questions on the witness, Mr. President. Mr. Lim, did I hear you correctly in response to the questions of Senator Defensor Santiago that the only time when you charge association dues is when there is acceptance?
Yes, Your Honor.
All right. And therefore, acceptance has nothing to do with the date when the deed of sale was signed.
Yes, Your Honor.
Acceptance has nothing to do when the date, with the actual date of registration of the deed of sale was done.
Yes, Your Honor.
In fact, acceptance has nothing to do when, by law, the ownership was transferred. Is that correct?
Yes, Your Honor.
Now, in fact, payment of union dues can be delayed. The payment of condominium dues can be delayed by the simple refusal of the owner to accept the unit. It can be delayed.
There is a possibility, Your Honor.
Yes, there is a possibility. And in fact, in this particular, in your position, you have no access as to when the titles were issued,
Yes, Your Honor.
nor when the titles were registered.
Yes, Your Honor.
That's all for the witness, Your Honor.
Actually, I think we are all confused about this whole thing, but actually it's simple as far as this chair is concerned. We are talking of asset. The asset originally was how much? 3-point-something million. That was transformed into a concrete asset known as condominium. But still, from the beginning of time of this contractual relationship, there was an asset. Only it passes from cash to a concrete thing known as a condo unit. The condo unit came into existence when it was actually constructed. But all along, there was an asset that must be reflected in one's SAL-N, whether it is in the form of a condo with a number placed opposite it, or a currency account with a number placed alongside with it. Isn't it? The consideration for the condo was an asset that ought to be reflected in the SAL-N of the buyer. So, whether we talk of pesos and centavos or unit, there was an asset from the very beginning. Okay?
We agree, Your Honor.
All right. Counsel, next.
Yeah, Your Honor, may we request that Mr. Lim be discharged?
The witness is discharged.
Yeah.
Thank you, Your Honor.
We would like a minute to call our next witness, Your Honor.
Proceed.
Thank you.